County Court, Law number 2, Jefferson County, Texas is now in session. First case that we have on our arraignment docket is cause number 325048. Case is style of State of Texas versus Leandro Castaneda Salceda. Mr. Bailey, could you please get Mr. Salceda? Mr. Wendler?
Yes, Your Honor. My client speaks Spanish.
Okay.
Interpreter.
What you call Jennifer?
I just had a chance to speak with the DA this morning.
Okay, hold on a minute. Our translator is coming in. Court is in session and calls number 325048. Case is style of State of Texas versus Leandro Castaneda Salceda. We have Mr. Salceda present in court. It has been brought to the court's attention that Mr. Salceda, he speaks Spanish?
Yes, Judge.
Okay. And we have our interpreter, Ms. Jennifer Raji. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret Spanish to English and English to Spanish? So help you God?
Yes, Judge.
Okay. Ask him if his name is Leandro Castaneda Salceda.
Su nombre completo es Leandro Casanova Sucero? Yes.
Okay. Ask him how he's doing.
¿Cómo estás? Good.
That's good. Now, Mr. Salceda is represented by his attorney, Mr. Walter Wendler. Mr. Wendler, how are you doing?
I'm great, Your Honor. Thank you.
That's good. Mr. Wendler, let's see, the state is represented by attorney Blake Ham. Attorney Ham, how are you doing?
Well, Your Honor, thank you.
That's good. And Miss Raji, how are you doing?
I'm great.
That's good. Now, Mr. Wendler, I see here that Mr. Salceda has a felony case set today in the 252nd District Court.
Yes, Your Honor. 10 o'clock.
Okay, so that case hasn't been handled yet, so it's set at 10. And so what we'll do is we'll hold your announcement until you let us know what happened down there.
Okay.
Okay, so y'all will come back here once y'all finish down there.
Okay.
All right,
All right. Thank you. Your
all
Honor.
right, so y'all free to go. All right, thanks a lot, Mr. Rudd.
Okay.
The other attorney is that Christian Capitan.
Good morning, Judge. How are you?
How are you doing?
Doing well. May I approach?
Yes. Is your client here?
Yes, Your Honor. He's outside, and he's also a Spanish.
Oh, get our interpreter. Okay, I didn't know.
And, I'm in the same circumstance, I think.
Okay, hold on. Court is back in session, and the court is in session in clause number 330324. The case is style of state of Texas versus Juan Damaro Marfin Alcazar. Mr. Marfin Alcazar speaks Spanish, and we have our interpreter, Ms. Elraji, who has previously been sworn in. Ask him if his name is Juan Marfin Alcazar.
Su nombre completo es Juan Morfin. Yes.
Okay. Ask him how he's doing.
Dice cómo está.
Bien.
Good.
Good, okay. And Mr. Marfin Alcazar is represented by Christian Capitan.
Yes, Your Honor.
How are you doing, Attorney Capitan?
Doing okay, Judge.
That's
How are
good.
you?
I'm doing fine. Thanks for asking. Attorney Capitan, what is your announcement in, well, I see here that Mr. Marfin Alcazar has a felony case set today in criminal district court. Is that correct?
Yes, Your Honor.
And what time is it set?
I believe it's at 10?
At 10?
Yes, sir.
Okay. So what we'll do, we'll hold off on your announcement and allow you to go down to the criminal district court. And once you finish there, you come back here and you can make your announcement.
Yes, Your Honor. Thank you
Okay?
very much.
So y'all excuse.
Thank
You excuse.
you.
Mr. Stone is out there. She just left felony court.
Next case is cause number 328020. Case is style the state of Texas versus Deandra Natasha LaFleur. Let's see. Mr. Bailiff, would you please call the name of Deandra LaFleur? Okay, Ms. LaFleur is represented by Attorney Terrence Allison. And Mr. Allison is not here. In his place is Attorney Rivers Allen. Mr. Attorney Allen, Deandra LaFleur is not present. Have you been in contact with her?
I spoke with her this morning and she's aware about the misdemeanor hearing, but she also has a felony hearing set at 10 o'clock in the criminal district court. So
Okay,
I'm not sure if she's over there waiting to be called or not, but I can give her a call right now and get it situated. But regardless, we need to wait until after the felony hearing to get this.
okay, well, we'll recall it after 10.
Thank you.
All right, you excuse. Would you call, okay, next cases are clause number 328720 and clause number 329186. Both cases are styled the state of Texas versus Richard Edward Vasquez. Would you please give Mr. Vasquez? Okay, your name is Richard Edward Vasquez?
Yes, sir.
How you doing, Mr. Vasquez?
Good.
That's good, Mr. Vasquez. You're represented here in your cases by your attorney, Mr. Nathan Reynolds. Mr. Reynolds is appearing via Zoom. Mr. Reynolds, how are you doing? Mr. Reynolds? Okay, he's on Zoom. Just have a seat in one of the chairs in the gallery that has the black and yellow tape on it. We go on to our next case. Next case is Misty Moss. Misty Moss. Court is in session in cause number 315782 and cause number 317030. Both cases are styled the state of Texas versus Misty Rennie Moss. Ms. Moss, is that your full name?
Yes, sir. It's
How you-
Renee.
Renee?
It's Misty Renee.
Okay. How you doing, Ms. Moss?
Okay.
That's good. Ms. Moss, I see here that you had a felony case set today.
Yes, sir.
And have you taken care of your felony case?
Yes, sir.
Did they give you a reset date?
No, they're going to have to pay the restitution and they're gonna drop it.
Did they give you another date, another court date?
Oh, yeah, they gave me
It's March 31st.
they gave me a court date, but she said I didn't have to come back if I got it taken care of before then.
Okay, we're gonna reset your case for March 31st of 2022. That's the same date of the felony case. Well, that just simply means that on that date, you need to come here. And I see here, she's representing herself, is that correct? Could you look up, does she have an attorney rep?
She is judge. She's also. Yes, she wanted to waive her right.
Okay, so you'll be here on March 31st of 2022?
Okay.
You're gonna stand on that 4X over there, and once she's gonna give you your reset. Once you get your reset, you'll be free to go, and you have a blessed day. Thank you.
Casey Harden is posted.
What?
Casey Harden
What about it?
on the bottom of page 2, posted.
This must be her announcement. Yeah, this is, I mean, not announcement, this is arraignment. Mr. Reynolds, are you available?
Yes, Judge, I'm here.
Okay, Mr. Vasquez, you can come back up. Court is back in session in cause number 328720 and cause number 329186. Both cases are style of state of Texas versus Richard Edward Vasquez. We have Mr. Richard Edward Vasquez who's appearing in court. And Mr. Vasquez is represented by his attorney, Mr. Nathan Reynolds. Mr. Reynolds, how are you doing?
I'm doing well, Judge.
That's good. Now, Mr. Reynolds, I see here that Mr. Vasquez has a felony case that is set today in the 252nd District Court. Is that correct?
Yeah, that's correct, Judge. He was set for trial this afternoon at 1 o'clock.
Oh, okay.
And I just received notice from the court coordinator that they're having to reset their trials and they're going to be sending me a reset on that case. So I
Okay.
asked that these two cases be reset on, they'll probably get a date by this afternoon if we could reset
Okay.
these on the same day.
Okay, so what we're gonna do, we're gonna reset your cases, Mr. Vasquez. We don't have a reset date right now. However, our court coordinator will be checking the computer system. And when they put a date in, that's the date will be sent to your attorney. Will be sent to your attorney, your bondsman. So stay in contact with your attorney, and your bondsman for your next court date. You're free to go and you have a blessed day.
You too, sir.
All right. And Mr. Reynolds, I think this is your only case. You're free to go as well and you have a blessed day.
All right. All right. Thank you, Judge.
You're welcome. Good morning. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come here this morning for arraignment because you have a case in this court. The case that you have in this court is classified as a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type cases, whereas your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious as your felony offense. And when I use the term serious, what I'm talking about is the range of punishment. That is the punishment that you can get for committing the offense. For a felony case, there are 5 categories of felonies. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. Now, the range of punishment in those particular categories, for example, for capital murder, if a person is convicted, they can get life or death. If a person is convicted of a first-degree felony, the range of punishment could be anywhere from 5 to 99 years to life in the state penitentiary, fine up to $10,000. For a second-degree felony, the range of punishment is anywhere from 2 to 20 years in the state penitentiary, fine up to $10,000. For a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. And for a state jail felony, which is the lowest felony, the range of punishment is 6 months to 2 years in the state jail, a fine up to $10,000. Now, for a misdemeanor case, your punishment cannot entail that you be sentenced to the state penitentiary. However, it can entail that you be sentenced to the county jail. Now, there are 3 categories of misdemeanors. You have a Class A misdemeanor, a Class B misdemeanor, and a Class C misdemeanor. Now, your Class A misdemeanor is your highest misdemeanor. If a person is convicted of a Class A misdemeanor, the range of punishment is anywhere from 0 days to 365 days in the county jail, which is 1 year, or a fine up to $4,000. For a Class B misdemeanor offense, the range of punishment is anywhere from 0 days to 180 days, which is 6 months in the county jail, a fine up to $2,000. And for a Class C misdemeanor is fine only. You cannot be sentenced to the county jail for a Class C misdemeanor. Now, your Class C misdemeanors are normally, those are cases that are appealed up to this court. And what I mean by appeal, for example, your Class C misdemeanors are handled in the JP court, which is a Justice of Peace court, or the municipal court, which is the city court. For example, it could be a traffic ticket. It could be not wearing a seatbelt. They have a whole host of Class C misdemeanors. Now, if your Class C misdemeanor is appealed up, in essence, you was convicted in the JP court or the municipal court, and you get a new trial when it's appealed to this court, and it's the range of punishment doesn't change, it's still the same. Now, as a defendant in a criminal case, you have rights. And the reason why I say that, because if for arraignment, the arraignment is just an opportunity for the court to tell you what your options are, which rights that you have, and the court will go over those options and rights that you have. Now, for example, you have a right to have an attorney. And as a defendant in a criminal case, you have 3 options. And that tablet or the clipboard that was handed out to you have that information on it. I will go over it with you. On the first page, it says, number 1, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. Now, if your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, then you will sign at the bottom of the document where it says defendant. And once you finish signing your name on the line that says defendant, then you would date it today's date, February 22nd of 2022. Now, if you are waiving your right to an attorney and representing yourself, then you would have to read and sign the second form. And the second form is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 22nd day of February of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you will sign on the line that says defendant, and you will date it today's date, February 22nd of 2022. Now, you also have other rights. You have a right to have a jury trial in your case. And what a jury trial is, that area where you see those young ladies sitting, we call that the jury box. They have 12 seats in the jury box. However, in a misdemeanor case, you have 6 citizens who will be selected from Jefferson County to sit on your case. They will listen to the evidence, and after listening to all of the evidence, they will deliberate and decide whether or not you're guilty or innocent. Now, you also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, that simply means that your case, you will not have a jury trial. However, your case will come before the court in one of 2 ways. It will come before the court by way of what we call a bench trial. And what a bench trial is It is a trial without a jury, and the judge will listen to the evidence, and the judge will decide whether or not you're guilty or innocent. And if you are found guilty, the judge will also assess punishment. Now, your case can also come before the court by way of a plea. And what I mean by a plea, that's an agreement that you have made either with the state. Now, your plea bargain, if you have made a plea bargain with the state of an agreement to settle your case, then it will come before the court, and the court has the option to follow or not follow the plea bargain agreement. If the court does not follow the plea bargain agreement, then you have a right to withdraw or take back your plea. Now, the other way that your case will come before the court, if you do not have a plea bargain agreement, it could come before the court by way of an unagreed plea bargain agreement. Unagreed just simply means that you and the state have been unable to reach an agreement to settle your case. And you want the judge to decide what the punishment will be in your case. So that would be an unagreed plea bargain agreement. Now, you also have a right to have witnesses to come to court to testify for you or against you. They sit in that chair over there. We call that the witness stand. Now, you also have a right to waive or give up your right to have witnesses to come to court. And that simply means that you will not be calling witnesses, but it does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. And you also have a right, if you waive your right to, you have a right to waive your right to have witnesses in your case. Now, you also have a right against self-incrimination. It's a Fifth Amendment. The United States Constitution, you have a Fifth Amendment right against self-incrimination. You may have heard it referred to as, I'm taking the fifth. In essence, I'm refusing to say anything. I'm refusing to testify against myself. You have that right. It's called a Fifth Amendment right against self-incrimination. Now, you also have a right to waive or give up your right, your Fifth Amendment right against self-incrimination. And what that means is that you will be testifying, if you waive your Fifth Amendment right, you will be testifying in your case. Now, also, you have a right to have discovery. And what discovery means is you have a right to see the evidence that the state has against you. The state has a right, is obligated to allow you to have access to that evidence that they have against you. And when the evidence, it could be witness statements, it could be other documents, it could be DVDs, it could be recordings, pictures. This is whatever evidence that they have. You have a right to have access to it. Now, if you're representing yourself, you will have access to it. But if you're represented by an attorney, then your attorney will have access to that evidence. Now, you also have a right to waive or give up your right to discovery, which means you have a right to say you don't want to have access to that evidence. Now, as a defendant in your case, since this is arraignment, you have an option. You can enter one of three pleas in your case. You can enter a plea of not guilty. If you enter a plea of not guilty, you're saying that I did not commit the offense that I have been charged with. Or you could enter a plea of guilty. If you enter a plea of guilty, then you're telling the court that I committed the offense that I've been charged with. Or you could enter a plea of no contest. And if you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges that the state has brought against you. Now, since you're here for arraignment, that just simply means that you're out on bond. In essence, you was arrested, placed in jail, and you're either on a PR bond, cash bond, or surety bond. Now, every day that you spent in jail, it can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you and the state have come to a plea bargain agreement that the agreement is for you to serve 5 days in jail. What that basically means is that you won't have to serve any more time in jail because the 5 days that you spent in jail will be used as credit toward your punishment. So you'll be given credit for time served. Now, if you spent 3 days in jail and they offer 5, that just simply means that you have to do 2 days in jail because they're gonna give you credit for the other 3. Now, every day that you spent in jail is also credited as $100 per day that will go toward your fine and your court costs. So if the state is offering you fine and court costs of $500, you spent 5 days in jail, that simply means that you will not have to pay anything toward your fine and court costs because you've already served 5 days in jail. And so the $500 will be taxed and retired because the time that you spent in jail has already paid it off. Now, if you spent 3 days in jail, that's $300, and they're offering $500, it just simply means that you have to pay $200. So if you can't pay the $200 on the day that you are actually entering your plea, then the court can allow you to pay it off in the future. That simply means the court can put you on a payment plan. You can pay so much per month toward your fine and court costs. But let's say you do not have a job or a source of income. You don't have the ability to pay it off, even if they even if the court puts you on a payment plan. Then that's not a problem either, because the court can convert your fine and court costs to community service. And what that means is that you will be working at a charitable center or institution in our community. And every hour that you work for community service, it will be credited as $12.50 towards your fine and court costs. So for example, if you work 8 hours of community service in a day, that's $100 that will go toward your fine and your court costs. Now, Jefferson County has a program. When I say Jefferson County, I'm talking about the district attorney's office. The district attorney's office has a program that is called pretrial diversion. Pretrial diversion is for first-time offenders. And what happens is if you get in the program, they dismiss your case. And once you complete the program, not only is your case dismissed, but you can get it expunged from your record. Expunged meaning wiped off, deleted, or erased from your record. And the way the program works is you have to, one, get an attorney to assist you with filing the application to get into the program. And 2, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And 3, it has to be your first offense. You can't have a criminal history. So if you meet the qualifications, you may get into the pretrial diversion program. Now, the other thing is this: if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has another program that is called Veterans Court. It is part of the pretrial diversion program. And once you get into the program, you complete the program, case is dismissed, you can get it expunged from your record. And I think the only criteria for you to get into that program is to be a veteran of any one of the branches of any one of the United States military. Now, this court has a program, County Court at Law Number 2 has a program that is called the Community Safety Initiative. It stands for CSI. It's the CSI program. And that program is designed to address the issue of what we call recidivism. Recidivism means people committing crimes over and over. They commit one crime, they continue to just commit crime, and they live in a life of crime. And so the way we address that is through our CSI program. Through the CSI program that I started in March of 2017, within 100 days of taking office or becoming judge in this court. I was able to get partnerships with some of the agencies in our community. We have a partnership with the Spindletop Center, and these young ladies that you see here is from the Spindletop Center. Now, Spindletop is a local mental health facility in our region. And the way the program works is Spindletop can do a private interview. They can not only do a private interview, but Spindletop can also develop an assessment and a treatment plan to address your mental health needs. And what I mean by mental health is not just somebody insane or incompetent, but a person could be bipolar, schizophrenic, paranoid. They can have anxiety, post-traumatic stress. It's a whole host of other disorders that a person may have. And so Spindletop, as I said earlier, they can do private interviews, assessment. They can develop a treatment plan, either outpatient or inpatient, to address whatever mental health needs that you have. Also, Spindletop has a program it's called ATAR. If a person is addicted to drugs or alcohol, then they have a program called ATAR. ATAR stands for Addiction Treatment and Recovery Program. That program is for individuals, their program actually is for individuals who are, I think, 21 years or younger. And for individuals who are above 21, we have a partnership with OZAR. OZAR is our local mental health agency. OZAR stands for Outreach, Screening, and Assessment Referral. They can do interviews, screenings, and they can develop a treatment plan and have you referred for either outpatient or inpatient treatment. Now, if you are unemployed, do not have a job, and you would like to get a job, or you like to get a better job, then we have a partnership with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And the only criteria is if you want to get into the program, just let the court know, and they'll be able to assist you at getting in to the program. The other issue, the other thing about that program, as well as the other programs, but Mr. Kimbler and Mr. Blake, y'all can talk in the conference room?
Yes, Your Honor.
Okay, now, the other thing about the program that they have at CICE, if you have not graduated from high school and you'd like to get a GED, they have a GED program. Now, all of these programs that I have just mentioned, all of these programs are free. It does not cost you anything. Only thing you have to do is just have a willingness to be in the program. And it takes a little time out of your day to participate in the program. Now, all of these programs are free, and they're designed to address the issue of recidivism, but moreover, it's designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to family, go to church. And the reason why I say it makes Jefferson County a safer place is because with that program, the program is designed to produce productive people. And we know that if we produce productive people for the most part will not commit crimes. Why? Because they have too much to lose. And so with our program, I say this, that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court, and we're trying to make a difference in Jefferson County, the county in which we live. Also, I tell people this all the time, that when you come to county court at law number 2, we do not just give time, we take our time. And we do not just arrest the problem, we address the problem. And we address the problem through our community safety initiative. And so if you're interested in the program, you can talk to one of our court personnel. We can be happy to give you any brochures or the information that you need for the community safe, for the CSI program, as well as the pretrial diversion program that are the Veterans Court program that we have here in Jefferson County. Now we have, as I stated earlier, we have some individuals from Spindletop. We have Deputy Hinton. Deputy Hinton, he can come forward. He can tell you just a little bit about the program that they have at Spindletop.
Thank you, Your Honor. Morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with my partner, Sarah. She's a qualified mental health professional with Spindletop. Now, the reason we're here is because the judge has graciously allowed us in this courtroom because he cares about every single person that comes before his court. Now, what the judge has found is people who appear in front of his court, legal issues, of course, commonly have mental health or substance use disorders. The judge believes that if we can address those issues, those underlying issues, we can get you out of the cycle of arrest, should this apply to you. Now, maybe it doesn't apply to you, maybe it applies to your family members. We'd love to speak to you about that as well. At the very least, we want to give you this information. This is a two-sided card. It's very simple. It has a 1-800 number on the front. Should you ever find yourself in an unsafe place, you can call that number and you can get help immediately. We'd like to give this to you. You can bring it to your family or however you want to address that. But as the courtroom goes into recess, I'll be visiting with y'all individually and talking to y'all, give you an opportunity to kind of find out what's going on and what we can do to serve you. Because no matter what you're going through, no matter how many times you've been here, there's still hope. And we can provide hope in the form of services, options, opportunities, and resources for y'all to help you. Do you have any questions? Thank y'all for listening. You're very kind. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, at this time, our court personnel is going to come by and get that paperwork that you filled out. And at this time, the court will be in recess. Sir, you have a case?
Yes, I do, Judge.
Okay.
Matt Oliver, I've got Bryson Adams on the docket today. I believe he's taken the custody.
Who?
Yeah. He wasn't on our docket. But he's there.
Oh, okay. Oh, where's the court, that's right, I've got to get the prosecutor. Yeah, our prosecutors in the back. You could have them to come back out. Okay. The court is in session in cause number 329-526. Case is filed the state of Texas versus Bryson Tyler Adams. We have Bryson Tyler Adams, President Court. Mr. Adams, is that your full name?
Yes, sir.
Okay, how are you doing, Mr. Adams?
Good, how are you?
I'm doing fine. Thanks for asking. And again, we're back in session. Well, we're in session and cause number 329-526. Case is filed the state of Texas versus Bryson Tyler Adams. We have Mr. Adams, who is present with his attorney, Mr. Matt Alford. Mr. Alford, is that your full name? Matt.
Yes, Judge.
Okay, how are you doing, Mr. Alford?
Fine, thank you. How are you?
I'm doing fine. Now, Mr. Alford is here representing Mr. Adams. Mr. Alford has informed the court that his client, Mr. Adams, I guess Mr. Adams received a letter from the court stating that his court date was February 2nd of 2022. Is that correct?
Yes. Speak up, please. Yes.
And, okay, and so Mr. Alford, I guess, has informed the court that when he talked to Mr. Adams and Mr. Adams asked him was the court, that Mr. Adams told him that the court date, that the letter was February 22nd of 2022. I mean, February 2nd of 2022.
That's correct, Judge.
And he asked his attorney, was the court date still February 22nd of 2022? Is that correct?
That's correct, Judge.
And so Mr. Alford is stating that the fact that Mr. Adams did not appear in court on February 2nd because he was informed by his attorney, Mr. Alford, that his court date was February 22nd of 2022. Is that correct?
That's correct, Judge, 100%.
Okay.
Otherwise, he would have been here, and I would
Okay.
have to.
Now, and on that particular date, on that particular date, the court forfeited Mr. Adams' bond. Okay, and so Mr. Alford is asking that the court set aside the bond because of those reasons that the court has just announced on the record. Is that correct, Mr.?
That's correct, Judge. Based on no fault of the defendant failing to appear and the subsequent forfeiture, we'd ask that the bond forfeiture be set aside and his PR bond be reinstated.
Okay, state, what's your position?
Your Honor, based on the representations of defense counsel, the state's not opposed to this request.
Okay, so pursuant to Article 22.13 of the Texas Code of Criminal Procedure, Section A3, causes which will exonerate, stating that the following causes and no other will exonerate the defendant and its surety, if any, from liability upon the forfeiture taken. And 3 states that the sickness principle or some uncontrollable circumstance which prevents his appearance at court, and it must in every such be shown that his failure to appear arose from no fault of his part. The causes mentioned in this subsection shall not be deemed sufficient to exonerate the principal and its sureties, if any, unless such principal appear before the final judgment on the bond to answer the accusation against him and show sufficient cause. And so basically it was a PR bond, and because it was a PR bond, the principal in the PR bond is Mr. Adams. And so therefore, based on Article 22.13A3, the state is going to set aside the bond forfeiture and reinstate the defendant's bond.
Thank you, Your Honor. Thank you very much. Thank you.
This is your letter.
Thanks.
And so, Mr. Alford, what is what is your announcement in Mr. Adams' case?
Announcement, judges, we are present and wanted to speak with, it was Mr. Boyd originally, he's been promoted. We have like to speak with the new prosecutor about some of the discovery status and discuss potential ways of plea bargaining or working the case out today, Judge.
Okay,
So we'd ask the court to hold.
okay, we'll hold.
Yes, hold for
Okay. All right, so
Thank
we'll hold. All right.
Thank you. We'll reapproach on a reset date. with-
Okay,
with Trina here shortly, if that's fine with the
well,
court.
that's fine.
Thank you. May the defendant be released.
Oh, yes, you can.
Thank you.